Good afternoon. This is Steve Wilkes at the Wagner Law Group in our San Francisco office. Thank you for joining us for today's webinar on ERISA cybersecurity, the next frontier. This is a really interesting topic. At our law firm, we cover just about every aspect of employee pension plans and welfare plans. So because so much data and processing of these plans is handled on technology platforms these days, we've had to learn to address the numerous and myriad cybersecurity and privacy and data protection elements of administering these plans. And it's become a very hot topic du jour in a very complicated area. And what I wanted to do today was provide some practical guidance when all is said and done in terms of what you might be doing either as a plan sponsor or perhaps as a platform provider or a financial advisor to a retirement plan. What we're going to talk about today is kind of what the issues are and a little bit of background, maybe using the financial services industry as a hypothetical example or framework, identify some of the legal and policy questions that have arisen, and then some recommended course of action for what you might be doing. I want to compliment the Department of Labor ERISA Advisory Council, where I testified on this issue back in May, because they've been considering this topic for a while. They mentioned it at some hearings a few years ago and again this past May. And in their advisory capacity, they've been pondering the question of what to recommend to the Department of Labor to do in terms of issuing guidance or taking a more formalized stance on these related issues. And the real question becomes, what's happening? What should a pension plan sponsor be doing or pension plan fiduciary be doing with regard to cybersecurity? Does it matter if you're a fiduciary or not? Does the identification and implementation of cybersecurity policy come under the penumbra of fiduciary activity for ERISA purposes? Is plan data a plan asset? Is there or should there be a role for plan participant to play in terms of safeguarding his or her own data? So what I want to do is talk a little bit about a little bit on the background, again using financial service industry as an example, maybe a quick status of where we are today in terms of the regulatory regime, and then raise some policy questions that need to be resolved, and then conclude with some practical steps going forward. Financial services is a good backdrop for pension plan cybersecurity conversation because so many of the players, banks, trust companies, advisors, custodians are embedded in the financial service industry, and of course as a plan sponsor you're dealing with a lot of financial data. There's a tremendous amount of financial information that flows to and from the various parties in a retirement plan setting. You have plan investments that are held at the omnibus and the participant level, plan account balances, individual account balances. Sometimes there's information about assets that are held away by that participant, general transaction inflows and outflows based on securities transactions, projected benefit levels, projected account balances, performance data, fees and expenses, and so on. There's often, of course, a set of related data that comes along with this information: name and address of a participant, name and address of a sponsor, identification of family and beneficiaries, account numbers, perhaps social security numbers, driver's license numbers, age, life expectancy, and so on. So there's a lot of information that flows in and around the operation and delivery of a retirement plan. Now, this issue of privacy and cybersecurity and social media, I think it all kind of flows together. They are discrete areas of the law. From a lawyer's lens, we could talk about each of them separately, but for purposes of today, let's blend them all together into one big bundle, and we'll just call it cybersecurity. And it's something that attorneys and consultants and regulators are all involved with. We see it as a headline constantly. It's the subject of a lot of proposed regulatory action, of a lot of proposed legislative action at both the federal and state level. For example, at the federal level, we have the SEC, which has an interest in guiding advisors and broker-dealers and other financial institutions, with privacy data. You have FINRA on the broker-dealer side, the Department of Justice, the Federal Trade Commission, the Office of the Comptroller of the Currency for banks, the Federal Deposit Insurance Corporation, just to name a few. And let me just make the point right now that we're talking today about retirement plans in the sense of qualified retirement, meaning a pension or a profit-sharing plan, a 401k plan. Welfare plans, which are governed by ERISA, which are subject to Department of Labor scrutiny, are a separate topic. And interestingly, even though both the DOL and the IRS have jurisdiction on many aspects of health and medical benefit programs, the regulatory regime with regard to cybersecurity of patient information and medical data is overseen primarily by the Department of Health and Human Services, which has a very robust set of regulations about the protection of PII and what happens in the event of data breach and notification and so on. So this is a big issue. We read about it in the paper all the time. Unfortunately, we read about breaches and hackers and what have you. I don't think there's too many places in the country or too many people in the country who don't have some understanding of what cybersecurity means in terms of their finance or their credit card or their bank statement. I don't think there are too many people who don't understand the potential of going online and doing something with personal information and having it jeopardized in some way. Pretty much everyone understands who a hacker is and what it means to be hacked. So it's a big issue, and it's getting bigger all the time. And even though we've made a lot of progress, there's still some open issues. I think that the risk of identity theft or loss of assets is something that we have to deal with every day. As I said before, the Advisory Council at the Department of Labor should be congratulated. They've done a great job trying to highlight these issues. They looked at it 4 years ago, and they identified some concerns that could be caused potentially by a lack of policies in the pension plan world, and identified some practical ways to go forward. I might try to summarize those a little bit later. And I think that they also identified different groups, maybe with different interests. Plan sponsors have their own interests. Participant and beneficiary has interests. Third-party service providers, clearly advisors, consultants, TPAs, record keepers, have a discrete set of interests. And the Advisory Council did make some specific recommendations back then about how the DOL might provide some guidance, but nothing has happened as of this date. I think it's a very tough issue for the DOL to get its handle around, and they're really overwhelmed and so busy on some other aspects of fiduciary regulation right now. This is an issue that's pending and brewing but hasn't quite been resolved yet. But that still leaves us, those of us in the pension plan world, that need to understand more about how employee data is used and how to protect it and what our responsibilities are as a fiduciary, as a non-fiduciary, just from a legal risk management point of view. I think that financial institutions that provide bundled services, are gathering all this data in order to create a, quote, personal experience for each plan and each participant. And the metrics that are coming over are staggering. As I said before, age, savings, risks, projected retirement dates. There's a tremendous amount of information that's being sought, and that's often linked with specific identifiable information about the identity or the account holder of the plan or plan participant. And even though the technology platforms on which these are being served are fairly complex and they're getting more sophisticated all the time, they're still subject to fraudulent activity and theft. So the appetite for more and more data is insatiable, and the opportunity for people to use it in the wrong way or to lose it or to be hacked grows proportionally. And I think this risk is something that is both internal and external. In other words, it's not just the plan sponsor and third-party financial service providers that have immediate access to this data, but all the other vendors that touch this in some way, IT providers, data storage companies, what have you. So it's a big issue. And the question is, what are we doing about it in the ERISA retirement world? What should we be doing about it? Let me talk about the law just a little bit, the current status of the law, because it's right now it's a patchwork. It's probably the best word. There's a tremendous amount of law at the federal level. Most of it's proposed. I mean, if you follow the newspapers, regulations and federal statutes are proposed constantly. And agencies like the SEC and the Department of Justice, the Federal Trade Commission are constantly updating their guidance, their auditing protocols, their alert, their enforcement initiatives. So the amount of activity on the regulatory side is huge. A lot of activity in terms of proposed legislation, but there is no single comprehensive federal law that governs this whole bundle of cybersecurity. We have a maze of statutes and regulations, both at the federal and state level, that are really not that integrated or coordinated. And in addition to that, there are just numerous guidelines and suggestions from the government which are considered best practices. They don't have the force of law, but maybe they create a standard of conduct. So the SEC, FINRA, Federal Trade Commission, they're all active with regard to enforcement at the national level, just like FINRA, of course, is active with regard to, its member groups, but each in its own sphere. And as I said before, the HHS, even though they deal with some ERISA-governed plans, those are on the welfare side. The retirement plan side is an area which is not yet fully developed in terms of understanding the framework for cybersecurity. Then, of course, the states are incredibly active. There are, I'll get into this in a few moments, but there are literally hundreds of laws at the state level governing aspects of privacy, Social Security number protection, driver's license protection. In California, a few days ago, they passed a statute which now protects the sanctity of your license plate, because a lot of bridges and tolls scan your license plate when you drive through, and that's now considered protected data, subject to cybersecurity protection. So there's a lot going on. Some of the more prominent areas in the financial service world that we see from the ERISA retirement plan point of view, of course, are GLB, the Gramm-Leach-Bliley Act, the original Privacy Act, which has implemented the regulation SP for broker-dealers and advisors. And this governs the collection and disclosure of financial information. It protects privacy rights of individuals by limiting how these institutions can share the information. And it directs that the SEC, as well as other regulators of other financial institutions, for example, the FDIC and the Office of the Comptroller of the Currency, are directed to handle the implementation of this law for banks. The SEC is directed to handle the implementation of this law for people in the securities world. So it directs that the SEC issue rules to implement certain privacy provisions, and the SEC has. It issued Regulation SP for financial institutions. And this sets forth, the rules about privacy notices, who they have to be given to, when they're given to you, the difference between a customer and a consumer, how you opt out, when you can or can't share this information. It also requires the establishment of procedures that are designed to protect client records and information. Interestingly, though, Reg SP protects individuals, not institutional clients. And the SEC has said that an individual plan participant is not a consumer or a customer. It doesn't necessarily enjoy the direct benefit of Reg SP. A pension plan, which is structured legally as a trust, is not an individual either. So these are all terms of art: consumers, customers, trusts, individuals. So there could be a little bit of a gap here in terms of how this plan data is being protected and evaluated in terms of the existing federal law under Reg SP. And, the SEC does note that it simply assumes that under state law, a trustee has its own fiduciary duty as to how to manage the affairs of the trust, including the duty to protect beneficiary data. This area is a little bit foggy, maybe needs to be clarified. So state law might cover individual employers and service providers, and it usually does in some way, but not arising from the fact that they hold pension plan data per se. It could be covered under other regimes. We also have Regulation SID, that's the red flags rule, identity theft rule, which has been adopted by the SEC and the Commodities and Future Trading Commission. We have the FTCA, the Federal Consumer Protection Law, that prohibits certain trade practices, and this can be used to cover cybersecurity. We have the Fair Credit Reporting Act and Fair and Accurate Credit Transactions Act. These, again, are federal laws relating to the handling of individual information by consumer reporting agencies. At the state level, as I said before, the states are very active with regard to privacy-related laws. California and Massachusetts usually lead the way. They're known to be, either a first adopter of a rule or to take a position. I mentioned earlier about the license plates. Now that California's come out, I think some other states will follow for example. But and the numbers change all the time. But generally speaking, at the last time I counted, 47 states had breached notification statutes, which is what one has to do when one becomes aware that its data has been breached or hacked. 38 states have specific laws about protection of Social Security numbers. 49 states and the District of Columbia have laws about credit report blocking laws, and 25 to 30 states, depending on how you want to count it, have rules regarding how you dispose of personal information, and a handful of states require encryption of customer data. So, by the way, encryption is sometimes a safe harbor. They say if you're following encryption methodology, then if you're hacked or leaked, okay, you did the best you could, you're not going to be liable. But in this California law I mentioned that was passed within the last few days, they've kind of narrowed the white list, if you will, or the approved list of encryption methodology. So encryption is okay, provided you do it in a certain way. That list is narrowing, and again, this is something to keep charge of. So, these laws vary state to state, and we have a patchwork at the federal level as well. It's really hard for a business to operate in more than one state and understand where its exposure is. It's hard for an employer with multiple state locations to understand how to operate across state lines in a compliant fashion. So there's a lot going on here. And we see, especially like during open enrollment periods, which is this time of year right now, a lot of data is being transmitted back and forth. And just trying to keep up with the privacy laws, the security laws, the breach laws, just a simple coding or data entry error could result in a breach. And it's time consuming, it's expensive, and it can be pretty complicated. Nonetheless, we have to have a policy. We have to figure out a way to stay on top of this to protect our plan participants. So let me try to mention a few of the policy questions, if you will, that I see, that my colleagues and I have talked about at the Wagner Law Group. And I think that just, as a matter of policy, number one, we have to ask, is there a gap between existing federal and state law and ERISA with regard to cybersecurity and the integrity of information that's flowing to and from, plan participants and third-party providers? And what does that imply? If there's a gap, how is it going to be handled? Who's liable? Who shares the risk? What does it really mean? The second question is, what's the role of the DOL? I think people assume and presume that when you're dealing as a plan fiduciary, it seems and feels fiduciary-like to have to be handling this plan data in the appropriate fashion. But is this something that the DOL would say is a fiduciary activity? And then the third question just involves, acts or omissions with regard to cybersecurity. Is this a fiduciary function under ERISA, or is it a set law function? And we could have some really interesting, academic conversations. As many of you know, sometimes a plan sponsor does something as the set law under old trust law, which means they're wearing their corporate hat. There are other times the plan sponsor dealing with the same plan. The fiduciary hat is on, and there's sort of an agreed-upon line of demarcation as to what set law activity encompasses and what fiduciary activity encompasses. Where does the plan data and cybersecurity fall in here? A lot of people assume it's fiduciary. I think that's something that we could use maybe a little guidance from DOL on, because we can make some pretty good arguments both ways. So, the DOL role on cybersecurity, as I said before, the Advisory Council, the ERISA Advisory Council back in 2010 or 11, it's probably the only time that there's really been a voice kind of speaking directly or indirectly on behalf of the DOL or with regard to the DOL role with regard to planned cybersecurity. And I think that Some interesting questions were raised. One, of course, as I said, being fiduciary status. This is a gating factor when you think about how the DOL might get involved in this area. There has to be some clarification around whether the responsibility to address planned cybersecurity is within the context of a planned fiduciary function or not. When you read the definition and when you look at the regulation as it exists or as it's proposed to define fiduciary, they don't really talk about cybersecurity per se. They do talk about management of a plan. They talk about discretionary authority administering a plan. So the question becomes, does managing and administering a plan, does that include the processing of data? And whether it's done in a cybersecurity sense or even manually, you still have a responsibility to protect the data with regard to privacy of personally identifiable information. So, where does this fall? I think it's kind of a related question, sort of an interesting question as to whether or not plan data is a, quote, an asset of the plan or not. So these are questions where we can use some guidance from the DOL. There's a lot of interesting thought around it, though it hasn't been articulated very much, which is why one of the reasons why we, the Wagner Law Group, have raised it from time to time, because we think it's an important area. I think DOL guidance, I think ultimately whether this is deemed to be a fiduciary act or not will sort of drive, how and when and what the DOL has to say. If the DOL determines that it's not a fiduciary act, then cybersecurity would be considered, a commercial responsibility, if you will, a set law function, a business function of the plan sponsor. The DOL can still offer guidance to plan sponsors regarding how they might want to handle this stuff. And I think guidance would also need to address the transmission and use and maintenance of data with third parties, like your financial advisors and record keepers. And the DOL could also be in a position maybe to identify the standard criteria by which plan sponsors would monitor and select vendors with regard to cybersecurity, and perhaps even to some model reps and warranties. We at the Wagner Law Group in our investment advisor agreements with plan sponsors and advisors for a number of years now have been inserting provisions about reps and warranties on some basic data integrity, privacy, cybersecurity things, and that's an area that I think everyone should look at in terms of their own agreement. So ultimately, I think that this guidance from the DOL, it'll certainly be considered, an industry best practice when it comes out, whether or not even if it's not a fiduciary activity, it would certainly be an industry best practice. And I think this has already evolved in some ways. If you look out and pick out 50 record keepers or 50 banks or 50 advisors or 50 plan sponsors and see what they're all doing with regard to plan data and plan security, then in effect, if this is what a plan sponsor does, it becomes the de facto standard by which all plan sponsors should act, and therefore it becomes part of that prudent standard by which everyone is judged on a fiduciary basis anyway. So one way or the other, it seems to, I think it's going to be working its way in there. So let me talk a little bit about some things that we might do, and maybe some more specific action steps that you can take. I mean, clearly we know that plan sponsors, are fiduciaries for the most part, and that they have to, act with prudence when they discharge their duties. And given the way technology is growing and the way people are doing things online, it certainly becomes reasonable to conclude that your actions around your technology platform and handling of data, handling of cybersecurity issues become part of the standard by which you're going to be judged. And as I said before, the ERISA Advisory Council has talked about this. They talked about the areas of vulnerability, including theft of personal identity and other personally identifiable information, theft of money from accounts, unsecured data, and other things like outdated passwords, just hacking into systems, email hosting and phishing, and stolen laptops. Given the way people use their smart devices these days, an employer or a plan fiduciary or just parties in part of any retirement plan delivery program have a lot of There are a lot of places on the roadmap they have to consider in terms of controlling the data, because it can move to and from not only multiple parties but multiple devices. So until we get some guidance, I think it's important for plan sponsors to have good procedures in place. And I want to point out, as I alluded to earlier, it may well be that if you're a plan sponsor, or a bank for that matter, or a service provider, record keeper, TPA, you're resident in a certain state or states, or operating across state lines. Maybe you're subject to federal regulation if you're a financial institution. You already have a variety of state laws in play and federal laws, but they don't specifically address the ERISA retirement scheme. So I think that you need to take a fresh look at the potential gaps in what the law does, and what the law does cover for you, and what it might cover with regard to your retirement plan activity, and just think about adding in additional procedures and steps to look at from a legal lens anyway, the ERISA claim that might arise in addition to any other state law, federal law claim you could be facing. So I think that one of the big areas, of course, is data. So what have we learned? What are people saying? Well, for one thing, don't keep more than you need. You should only be storing and using data that you really need to implement your retirement program. And be careful about how you maintain backup copies, with stored copies, whether it's paper or electronic, but how you're backing up your data. I think you have to know where it is. What server or servers is it stored on? Who has access to it? What are the different security levels of different people that have access to it? And you have to really understand, again, how that data is stored and protected. It's important to invest in technology. It's an expensive proposition because it never ends, but I think it's really important to keep your systems updated and keep your software updated, to follow guidelines from your computer consultants, follow best practices that have been espoused by relevant agencies like the SEC or FINRA or the Federal Trade Commission with regard to certain practices. And the National Institute of Security and Technology has guidelines on computer configuration use, which are outstanding. You should use encryption when you can, especially on your laptops and external data storage devices that might include information. And really maintain a good login process, for the network and for the routers and for software, to really limit who is getting into these systems and where they get in and how they get in. I think the biggest area of improvement at the moment would be what we call third-party management. A lot of times, an employer might feel as though it has its own house in order. It hires employees, it keeps good records on their Social Security numbers, driver's license number, whatever part of the employment process is. People enroll in the retirement plan, and they gather some data, and the employer might feel as though that data is pretty secure, but it moves around to a lot of different parties once you're engaged in the rollout and delivery of plan services. I think it's very important to get good reps and warranties from your service providers, to have a good due diligence on your service providers, and even do some random checking on your service providers to ensure that not only you, but that they are handling your employee and your participant plans data properly. So you want to make sure that you're monitoring these people and who of their employees, who of your vendors' employees have access. You want to include privacy and security just when you're vetting and selecting these providers. You want to ask questions as part of your due diligence. You want to find out what kind of processes they have they ever had a breach, how do they handle cybersecurity threats, are they in compliance with all the laws, state and federal, ask them to name those laws. You want to know if the third party is using any subcontractors, that this diligence flows down the line, that your third party vendor asks of its own subcontractors the same standards that you are asking the third party vendor. Keep good files internally for yourself as part of your own compliance procedures. Keep a good record of your own diligence efforts that show what you're doing to maintain security internally and to ensure that your third-party vendors are maintaining security, that they have the right systems in place. You want to check with maybe your computer consultants if you have them, if your processes and procedures seem to work right and you're asking the right questions. Also ask of your legal counsel through a legal lens whether you and any third-party vendors with whom you're doing business are compliant with the applicable laws and that you know what those laws are. I think it's also a good opportunity to think about internally with your employees. You want to educate your people about how to safeguard data and how to, if you're a plan sponsor, you want to be telling your plan participants and beneficiaries to be careful, watch out for phishing, make sure they log in properly, make sure they don't share their online 401k account information with anybody. And this is the kind of thing where you might want to have a system in place of, passwords, double logins, PINs, and things like that, so that before benefits are paid out, for example, it might be good to have a double login or some sort of confirmation for the participant before money comes out. You want to have good training internally for all your people on the privacy laws and procedures, good background checks, keep good records of any problems you've had, whether they're alleged or real, and how you the steps you took to identify and remedy those problems. Fiduciary liability insurance is something to think about. If those of you who think that you are acting as a fiduciary, you should ask your provider, does this include any cyber insurance, if you will, any cyber security threat? Or as a more general question, you might want to see if you have the opportunity or need to look at cyber security insurance as a separate policy, which is an emerging product expanding rapidly in the marketplace. You might want to consider an overall review of your internal policies and procedures to make sure that cybersecurity is properly addressed, and to make sure that that you test yourself every now and then, that you try to do some risk assessments and see what sort of controls you have in order to maintain that. So I think that the thing about the cybersecurity is that it's a little bit, we know that there are laws out there at the state and federal level. We know that it's a big problem. We know that you're handling plan information and participant level information. There's some laws at the Fed level, a lot of laws at the state level. I'm not quite sure exactly how they apply in every facet circumstance, but we know that there are some problems out there, and it's a concern, and that plans are vulnerable just in terms of, their data and their technology and the third-party providers, and they have to deal internally with training people. And then it's especially hard for smaller businesses that don't have all the resources. So again, you want to keep what you need, have good processes to keep and discard of data, keep your systems updated, make sure the software is updated, stay current on the best practices and guidelines that might be applicable to your business, whether it's from the SEC, FINRA, the National Institute of Security and Technology. Use encryption when you can. Try to control not only your internal devices, but all the smart devices that are out there floating around with your employee network. Train your people. Look really hard at your third-party vendors in terms of selecting and performing due diligence on who those providers are and how you monitor them, and also how that flows through to their own subcontractors. Be very clear internally as to who has access to PII and who doesn't. Make sure you have good controls and you have a process in place that identifies who's in charge of cybersecurity at your firm, and that this policy is communicated to all the applicable parties. So I hope this has been helpful. I think one of the takeaways, again, people still say, well, is this a fiduciary issue? I think that's an issue that remains to be fully clarified, and maybe the Department of Labor will help us in that regard. But I think just from the best industry practice point of view, you should assume that it's a very high-level fiduciary-like, if not an exact fiduciary issue in terms of ERISA, and have the appropriate plans and procedures in place to address cybersecurity. Thank you very much for attending today. I hope this was helpful for you. And if you have any questions, please email me at the Wagner Law Group or call me in San Francisco, and I will be glad to handle any of your questions. Thank you very much, and have a great day.